Florida judge has found himself at the center of a media firestorm after a bizarre and unprecedented sequence of events. A six-figure fine for insulting President Joe Biden, followed almost immediately by an arrest carried out by none other than Attorney General Ashley Moody and law enforcement officers in Bondi. The situation, which has sent shockwaves through political and judicial circles alike, raises serious questions about the limits of free speech, the independence of the judiciary, and the role of law enforcement in politically sensitive cases. It all began during a routine court proceeding when Judge Richard Harlan, known for his sharp tongue and unfiltered commentary from the bench, went on what many are calling a politically charged tirade. During an unrelated sentencing hearing, Harlan allegedly criticized the Biden administration's immigration policies, referring to the president with language that some courtroom attendees described as grossly unprofessional and borderline seditious. Although court transcripts have not been officially released, multiple witnesses claimed the judge called Biden a danger to democracy and accused him of weaponizing federal institutions to target political opponents. The courtroom fell into stunned silence, and a complaint was swiftly filed by a government attorney present during the hearing. What happened next was nothing short of historic. Within 24 hours, a judicial conduct panel convened an emergency session and issued a fine of $100,000 against Judge Harlan for what they described as a blatant violation of judicial ethics and an extraordinary abuse of the court's impartiality. The fine, unprecedented in its size and speed, was intended not only as a punishment, but as a warning to other judges tempted to use their benches as political pulpits. But things didn't end there. Moments after the fine was issued, and before Harlan could even leave the courthouse, state authorities arrived, led by Attorney General Ashley Moody, who was in Bondi at the time. Harlan was placed under arrest on charges that have yet to be fully detailed, but sources suggest they include misuse of judicial office, conduct unbecoming a judge, and possibly even incitement. Legal experts are still debating whether the arrest was lawful or merely theatrical, but the optics of the incident have already created political ripples across the state. Moody's personal involvement has added fuel to the fire. Critics argue that her presence turned the arrest into a political statement, suggesting that the state is cracking down not just on judicial misconduct, but specifically on anti-Biden sentiment within the judiciary. Supporters, however, say Moody was simply doing her job and taking swift action in the face of judicial overreach. Her office released a brief statement saying, "No one is above the law, not even those tasked with interpreting it." The legal community is split. Some lawyers and former judges are calling the arrest an alarming overreach of executive power, pointing to the separation of powers doctrine. Others argue that Harlan's comments went beyond protected speech and into the realm of judicial malpractice. According to one legal analyst, when a judge attacks the president in open court, especially in language that calls into question the legitimacy of federal authority, that crosses a line from free expression into dangerous politicization. Meanwhile, public reaction has been swift and polarized. Right-leaning media outlets are painting Harlan as a free speech martyr, a judge punished for speaking out against what he perceives as federal tyranny. Left-leaning commentators, on the other hand, are calling it a long-overdue reckoning for a rogue judge who crossed ethical lines. Social media is ablaze with hashtags like #FreeJudgeHarlan and #JudicialJustice, reflecting the divided national mood. As Harlan awaits a formal indictment, legal observers are watching closely to see whether this case sets a new precedent. Could other judges face punishment for political speech? Will the judiciary become more cautious in its public commentary, or will this lead to further resistance from those who feel their voices are being silenced? As Judge Harlan sits behind bars, his legal team is preparing what they claim will be a vigorous defense. His lead attorney, Marcus Tillman, held a press conference outside the Bondi courthouse, declaring the charges against Harlan to be purely political theater and an assault on the independence of the judiciary. Tillman stated that Harlan's remarks, while strongly worded, were constitutionally protected and delivered in a context that did not interfere with the actual proceedings. According to Tillman, The judge was expressing concern over broader federal issues that affect state-level court operations, particularly in cases involving immigration enforcement. "What we're witnessing is not justice," Tillman said, "but retaliation." He further hinted that the defense might seek to move the case to federal court, arguing that the arrest was a violation of Judge Harlan's constitutional rights, particularly under the First and 14th Amendments. Meanwhile, supporters of the judge have begun organizing protests in Bondi and across Florida. Demonstrators have gathered outside government buildings, carrying signs with slogans like "Silencing the bench" and "Judges have rights too." Among them are several former colleagues and clerks who worked under Harlan, many of whom describe him as tough but fair and someone who never hesitated to speak his mind, even when it cost him politically. On the opposite end, civil rights organizations and legal ethics watchdogs have applauded the state's swift response. One group, the Judicial Accountability Network, released a statement calling Harlan's conduct a betrayal of the robe. They argue that allowing such behavior to go unchecked would set a dangerous precedent, especially in an era where the courts are being pulled into increasingly political battles. "Judges are not above scrutiny," the statement read. "When they misuse their power to push personal agendas, consequences must follow." Adding another layer to the unfolding drama, reports have surfaced that the FBI is now monitoring the case. While they have not issued any official comment, sources close to the investigation say federal authorities are evaluating whether any of Harlan's courtroom remarks could constitute a broader pattern of political bias or misconduct that may have influenced prior rulings. If such evidence is found, it could open the door to retrials or appeals in past cases he presided over, a nightmare scenario for the legal system. Political fallout has also begun to take shape. Several Florida lawmakers are calling for a legislative review of judicial disciplinary procedures, while others are accusing the state government of trampling over due process. Governor Ron DeSantis has so far remained silent on the matter, but sources inside his office suggest he's monitoring it closely, aware of the potential implications for judicial oversight and the balance of power in the state. Nationally, legal commentators are comparing the situation to landmark moments in U.S. judicial history. Some are even referencing the case of Alcee Hastings, a federal judge who was impeached in the 1980s, suggesting that we may be witnessing the early stages of a similar process, though this time with the twist of state-level enforcement stepping in ahead of federal action. In Washington, President Biden has yet to directly comment on the controversy. However, White House Press Secretary Karine Jean-Pierre briefly addressed it during a daily briefing, stating, "The president believes in the independence of the judiciary and the importance of maintaining decorum and impartiality in our courtrooms. Any action taken against a judge should be based on law, not politics." The comment, carefully worded, seemed to strike a middle ground, acknowledging the gravity of the situation without appearing to endorse the punishment or the arrest. But to many, it was also a reminder of the deep political fault lines now, cutting through all three branches of government. As the media frenzy grows, legal scholars continue to debate what the long-term impact of this case might be. Will judges now self-censor to avoid stepping into controversy? Will this embolden politicians to more aggressively monitor the judiciary? Or will the courts rally to reaffirm their independence in the face of what some are calling political persecution? One thing is undeniable. Judge Harlan's case is a flashpoint. It represents more than a single judge's fall from grace. It's a symbol of the broader tensions facing America's institutions. The clash between free speech and judicial conduct, between politics and the law, has never been more visible. As new developments emerge daily, the entire country watches, waiting to see whether this judge will walk free as a defender of truth or fall as an example of what happens when power and politics collide inside a courtroom. Back inside the courtroom where it all started, the scene has shifted dramatically. Judge Harlan's once commanding seat at the bench now sits empty, replaced by a rotating series of temporary appointees. The courtroom staff, many of whom worked with Harlan for years, are reportedly shaken and unsure of what the future holds. Whispered conversations and guarded glances have become the norm, as everyone waits to see how the investigation plays out. Behind closed doors, state officials are reportedly scrambling to ensure that this incident doesn't spiral into a larger, institutional crisis. The Florida Judicial Qualifications Commission has launched a parallel investigation into Harlan's past rulings, questioning whether his political views may have skewed his decisions over the years. This has led to concerns from defense attorneys and public defenders alike, who are now combing through transcripts of old cases to see if appeals may be warranted. One defense attorney, speaking anonymously, said, "We're being told to look at anything that involved immigration, voting rights, or even federal grants. If there's a chance Harlan ruled with bias, that could reopen dozens of cases. If that happens, the Florida court system could face an overwhelming backlog, and taxpayers might end up footing the bill for retrials and investigations that could stretch for years." Meanwhile, in the public square, the conversation has expanded beyond Harlan himself. Commentators on both sides of the aisle are using the case to make larger points about the role of politics in the courtroom. Conservative outlets are raising alarm bells about judicial free speech, warning that this case could set a precedent for punishing judges simply for their opinions, especially if those opinions challenge the federal government. Progressive voices argue the opposite, that unchecked commentary from the bench erodes trust in the justice system and blurs the line between law and ideology. Some are even calling for nationwide reforms, suggesting that judges receive regular training on ethics and the boundaries of personal expression within their roles. While legal experts debate, Harlan's supporters have started a crowdfunding campaign for his legal defense. The campaign raised over $500,000 in just 3 days, further highlighting how deeply this case has resonated with a significant segment of the population. Their message is clear. Judge Harlan spoke the truth, and he's being punished for daring to defy the system. His detractors, however, are pushing for permanent disbarment and even impeachment. A petition demanding his removal from the bench has garnered over 100,000 signatures, with signatories arguing that judges who let political bias infect their rulings must be held accountable to preserve the sanctity of the judicial process. The Department of Justice has so far remained silent, but insiders suggest that federal observers are being briefed regularly. There is quiet talk that, depending on the outcome of the state-level proceedings, federal charges could be considered if evidence emerges that Harlan's actions crossed legal boundaries, particularly in terms of abuse of power or obstruction of justice. As of now, Judge Harlan remains in a state facility awaiting his preliminary hearing. His legal team has filed for immediate release on bond and a formal motion to dismiss the charges, citing both constitutional violations and lack of legal precedent for arresting a sitting judge under these specific circumstances. The hearing is expected to take place within the week and will likely be broadcast live, drawing in millions of viewers across the nation. Media crews have already set up camp outside the courthouse, turning the small city of Bondi into the epicenter of one of the most controversial legal battles in recent memory. Analysts are comparing the unfolding saga to the Brett Kavanaugh hearings or the impeachment of judges like Samuel Kent, noting that these rare moments in judicial history tend to leave lasting marks on the system and public perception. And then there's the human element. Judge Harlan, once known as a fiercely independent jurist with a sharp wit and a reputation for being unshakable, is now portrayed in vastly different lights depending on who you ask. To some, he's a villain who abused his authority for political, and to others, he's a hero paying the price for speaking out. Either way, this case has already altered the conversation around judicial power in America. What began as a moment of frustration voiced aloud from the bench has spiraled into a full-scale constitutional confrontation. Its outcome could redefine the balance between free speech and judicial decorum for decades to come. As the sun sets over the Bondi courthouse, the cameras stay rolling, the debates rage on, and Judge Harlan sits waiting, at the heart of a storm that shows no sign of passing.